दोस्तों नमस्कार। जयपुर हाईकोर्ट ने राजस्थान हाईकोर्ट ने जयपुर सीरियल ब्लास्ट जो 13 जुलाई 2008 को हुआ था उसमें सभी अक्यूज को बरी कर दिया है और इन्वेस्टिगेशन के ऊपर काफी बड़ा हमला किया है। आप लोगों की सहूलियत के लिए, सुविधा के लिए मैं जजमेंट पढ़ रहा हूँ। हाई कोर्ट ऑफ जुडिकेचर फॉर राजस्थान बेंच एट जयपुर, 132 पेज का जजमेंट है। डिवीजन बेंच क्रिमिनल डेथ रेफरेंस नंबर 2 ऑफ 2020, स्टेट ऑफ राजस्थान थ्रू पब्लिक प्रोसिक्यूटर पटिशनर सैफुर एलियास सैफुर रहमान रेस्पोंडेंट, connected with division bench criminal appeal DB number 216 of 2022, Saifur Rahman petitioner versus state of Rajasthan through its public prosecutor, Mohammad Sarwar Azmi, Mohammad Safi, Mohammad Salman versus state of Rajasthan through public prosecutor, respondent DB state of Rajasthan through public prosecutor Shahbaz Hussain, Mohammad Safi, Mohammad Sarwar Azmi, Saifur this and that। इसमें वकील थे राजस्थान गवर्नमेंट की तरफ से रेखा मदनानी एडिशनल जीए, असिस्टेड बाय मिसेस सविता अथावत। एक्यूज की तरफ से ये लोग थे नित्या रामा कृष्णन सीनियर एडवोकेट, असिस्टेड बाय विभोर जैन, शिवम शर्मा, मयंक चोपड़ा, सैयद सदात अली, दिस एंड दैट, ये लोग थे। देख लो, ये जजमेंट दिया है पंकज भंडारी ने और समीर जैन ने। जजमेंट है, ये जजमेंट रिजर्व हुआ था 3 नवंबर 2022 को और प्रोनाउंस किया है 29/3 को। पंकज भंडारी साहब ने जजमेंट लिखा है। DB criminal death reference number 2 of this DB criminal appeal 216/2022, 217/2022, 255/2. Present DB criminal death reference has been moved by Court of Special, moved by Special Judge Jaipur Bombay Blast Jaipur for confirmation of death sentence awarded to the court by judgment of awarded by the court by the judgment of conviction dated 18/12/2019 and order of sentence dated 20/12/19 to accuse Mohammad Saifur Rahman in session case number 2A 2010 State versus Mohammad Saif and others, FIR number 118 of this police station Kotwali Jaipur, agreed by the judgment of conviction dated so and so, order of sentence in sessions court, accused Mohammad Saifur Rahman preferred DB this and this. By the aforesaid judgment, Shahbaz Hussain, Shahbaz Ahmed Sahu was acquitted from the charges leveled against him. State of Rajasthan has also prepared DB criminal appeal number 252 against acquittal of Shahbaz Hussain and this. इसमें मोहम्मद सैफुर के ऊपर 302 में डेथ पेनल्टी, 50,000 रुपए फाइन, 307 7 years रिग्रेस इम्प्रिजनमेंट, 10,000 फाइन, 326 5 years रिग्रेस 10,000 फाइन, 324 3 years 500 फाइन, 427 1 year सिंपल इम्प्रिजनमेंट 1,000 फाइन, 121 लाइफ इम्प्रिजनमेंट 50,000 फाइन, 124 लाइफ इम्प्रिजनमेंट 50,000 फाइन, 3 years रिग्रेस 50,000 फाइन, under section 3 of Explosive Substance Act, life imprisonment 50,000 fine, 13 of Unlawful Activity Prevention 1967 7 years fine 50,000, 16 this unlawful activity prevention death penalty 50,000। ये सबके बारे में लिखा गया है, ध्यान से देखते रहिए, ये बहुत काम की चीज है। ऑल सेंटेंस आर डायरेक्टेड टू रन करेक्टली। ये लिखा है, subsequently stated the fact of the case are that a spate of explosion took place in the crowded market places in the walled shipping city of Jaipur on 13th May 2008 with a short span of 20 minutes resulting into the death of 71 persons and injuries of 185 persons. In each of these blasts, the bombs were planted on brand new bicycle which were placed at carefully selected crowded marketplace near temples and police station. In total, 8 FIR were registered, 5 FIR were registered at police station Kotwali and 4 were registered at police station Manak Chawk. The case pertained to FIR number 118, Police Station Kotwali, Jaipur. The author of the FIR was Badan Lal Saini. The place of incident of blast in this FIR is Phul Walon Ki Khanda, Chhoti Chaupad. Total number of persons injured are 15. Of those who died in the blast are 2. Now, the next day of the incident on 14/5/2000, email was received by TV channel and agency India TV and Aaj Tak by which Indian Mujahideen organization took the responsibility of serial bomb blast in Jaipur. Along with email, one video clip was also received, which pertained to bicycle and a bag on that bicycle. In the first part of the email, there was a mention about the bicycle with frame number so and so, which was placed near police station Kotwali at Chhoti Chaupad. The bicycle with the same frame number was seized from the blast site near police station. In the operation, 2 terrorists, Chota Sajid and Atif Amin, were killed, and one police officer, Inspector Mohan Sichand Sharma, expired. Accused Muhammad Saif was arrested from the flat. On 2/10/2008, accused Muhammad Saifi made a disclosure statement which was recorded by Delhi police. Saif admitted in his active role in the Jaipur bomb blast and also named 9 other accused and the direct involvement in planting the bombs at various places in Jaipur. In the disclosure statement, it was mentioned that all these 10 accused had come in groups of 11th May 2008 to reconnaissance recce on the places where they intended to plant bombs and return on the same day. On 12th May 2008, they made bombs at Batla House and so and so. They all came to Jaipur in a Volvo bus in different groups and returned back on the same day in the evening by Ajmer Shatabdi train in fake Hindu names. Muhammad Saifur Rahman was identified in test identification parade by Lalit Lakhmani, owner of Hemra Cycle, and this, after due investigation, charge sheet was filed. The trial court framed charges under so and so, so and so, so and so, so and so, so and so. The accused denied the charges and sought trial, upon which the session case number so and so. In session case number so and so, witnesses were examined. Document exhibit P1A exhibit were exhibited and Article 1 to 51 were exhibited on behalf of the prosecution. Accused were examined under Section 313 of CRPC. In defense, Exhibit D1, D13 were exhibited, and one witness, namely Muhammad Saif, was after hiring the parties. The learned trial court has convicted the accused of the offences stated above, agreed by which Muhammad so and so have preferred the present appeal against the acquittal of Sahbaz, and this state has preferred appeal. References has been made by the Special Judge Jaipur bomb blast for confirmation by sentence of Saifur Rahman. It is contended by the learned additional government that these cases are rest on circumstantial evidences. The first circumstances against Saifur Rahman is that his name was mentioned by accused Muhammad Safi in his disclosure statement dated 8/10/2008, and thus accused Muhammad Safi was arrested in Batla House and counter case for Delhi bomb blast. It is his arrest that gave a breakthrough to the ATS investigation of Jaipur bomb blast. In this disclosure statement, Saif named 9 other accused who were involved in planting bombs at various places. It is argued that there was no pressure of unaccused Muhammad Saif to make an admission to the offense of planting bombs in Jaipur. After 4 months of incident, the disclosure statement of Muhammad Saif was later on corroborated by the disclosure statement of accused Saifur Rahman is thus relevant under so and so. It is contended that next circumstances against accused Saifur Rahman in his admission before the CGM Bhopal about his involvement in Jaipur and Faizabad bomb blast. This fact, according to learned and additional government advocate, is mentioned in the order sheet of the CGM Bhopal, exhibit so and so. It argued by learned additional government advocate that there was no pressure on accused Saifur Rahman to admit his crime as he was before the CGM. The admission by accused Saifur Rahman about his involvement both in Jaipur and Faizabad bomb blast before the CGM Bhopal is a very strong and incriminating circumstance against accused. This, according to learned additional government advocate, the next circumstance against Saifur Rahman is his disclosure statement by him in a FIR so and so police station Kotwali, in which he has stated that he planted bomb behind flowers of Chhoti Chaupad and identification memo of a place of this. It is contended by learned and this gave a disclosure statement on so and so that he purchased cycle from cycle market, which is near Chhoti Chaupad. He also stated that he can point out the place where he planted the bomb behind flower shops. At the instance of accused Saifur Rahman, a site plan was prepared, which is exhibited as so and so. It is argued that it was for the first time that It came to the notice of the police that it was Saifur Rahman who had placed the cycle behind flower shop in Chhoti Chaupad, and thus it is fact discovered in terms of Section 27 of Evidence Act. It is also argued that Saifur Rahman has not only admitted his crime by planting bomb at Phoolon Ka Khanda behind flower shops Chhoti Chaupad, but he has also corroborated his closer statement of accused Muhammad Saif and admitted the offense of conspiracy in serial blast. The next circumstance, which is the main circumstances against accused, is his identification by Lalit Lakhmani, owner of the cycle shop, in the test identification and later identification of this. It is argued by Leonard this that in the bill number dated so and so frame number of her cycle silver color black color was mentioned. Similarly, the cycle which was recovered from the blast site was also not having any frame number. Thus, it is proved that the cycle which was sold by Lalit was the cycle which was used at the blast site. It is contended that Lalit Lakhmani has deposed that on so and so a person aged 24 years purchased a Hercules cycle of silver black color. However, the bill mentioned the date as 12/5, which was wrongly written by mistake. He has also deposed that in reality he had sold the cycle on 13/5. It is argued by learned additional advocate that the statement of this was recorded under 161 of CRPC on the very next day of the incident, in which he has wrongly mentioned the date of sale of cycle on bill as so and so. इसके बाद Leonard Governor Council has drawn our attention to Exhibit 80 argued by Leonard so and so was examined. He has deposed that he remembered the physiognomy of accused as accused neither saw any other model of cycle nor negotiated on price. However, he has deposed that he has two shops in Chandpole Bazar. One is shop number 84 Hembra cycle and second is Hariom cycle. He also deposed that he sits on Hembra cycle and his father and younger brother sits on the other shop. Dalit Lakhmani has stated that he remembers the purchaser of the cycle as he has sold the cycle on 13/5 and on the same day there was bomb blast in the evening. It is argued by London that since the statement of the was recorded on the very next day of the incident, it is very natural for the cycle owner to recollect the physiognomy of this. The next circumstance is his identification by witness in the court. The next circumstance against accused is his call details with other co-accused in the case of prosecution that so and so. अब यहाँ पर ये call detail की बात कर रहे हैं. लंबा जजमेंट है, थोड़ा टाइम लगेगा, फिर भी देखिए. आर्गुमेंट चल रहा है. ये साइटेशन रेफर किए जा रहे हैं, इसमें ऐसा हुआ था, उसमें हुआ था. अगर आपको चाहिए किसी को तो आप मेरे मेल पे कांटेक्ट करें, मैं आपको भेज दूंगा. लेट्स कम टू द कंक्लूजन पार्ट ऑफ इट. ये पूरा साइटेशन चल रहा है, इस केस में ये हुआ था, उस केस में हुआ था, जो नॉर्मली कोर्ट करता है. यहाँ क्या बोल रहा है, यहाँ पर ये बात कर रहे हैं एविडेंस वैल्यू ऑफ डिस्क्लोजर लीडिंग टू रिकवरी बी की बात कर रहे हैं. 36 देखिए 90 पेज पे है ये. We have to consider the contention and have carefully perused the evidence on record with regard to accused Sahbaj. The main CPU, which while deciding death reference number 134, this court has come to the conclusion that prosecution has not been able to establish beyond reasonable doubt Talwala, Saib, Sarwar, Ajmi, and Salman in Jaipur, Bamlas. While deciding reference number 7, we have come to the conclusion that Muhammad Salman is not guilty in death sentence. We have held Muhammad Sarwar Ajmi as not guilty and death reference number so. We have held Muhammad Safi as not guilty since the prosecution has failed to establish beyond reasonable doubt the guilt of Muhammad Sarwar Ajim. Saif and Mohammad Salman, they cannot be held guilty as co-conspirators in the present case. Again, this point is also decided against the state and in favor of it. Before we conclude, we must place on record the fact that we are not aware of the degree of agony or frustration that may be caused to society in general and families of the victims, in particular by the fact that a heinous crime like the goes unpunished, but then law does not permit the court to punish the accused on the basis of moral conviction or suspicion alone. It is always the burden of the prosecution to prove their case beyond reasonable doubt on the basis of actual evidence. Apex court in Sarwan Singh so and so. It is well settled principle of criminal jurisprudence that more serious the offense, the stricter the degree of proof, since higher degree of assurance is required to convict the accused. From what we have discussed here and above, it is evident that the prosecution has failed to establish beyond reasonable doubt that Saifur Rahman came to Jaipur in the name of Ajay Singh, planted the cycle near Pool, Manak Khanda, Chhoti Chaupad, and left by Ajmer Shatabdi train on the same day. We therefore declined the reference, allow the appeal filed by the accused Saifur Rahman, Muhammad Sarwar Ajmi, and dismiss the appeal filed by the state, challenging the acquittal by Sahbaz and for the enhancement of sentence of Salman so and so. server are acquitted, and judgment of the trial court to the extent it has acquitted Sarvaj is upheld. Consequently, division bench so and so is declined. So and so are allowed, and accused Saifur Rahman, Muhammad Sarwar, and are acquitted of other charges. Division bench criminal appeal preferred in the state is dismissed. The impugned judgment of conviction dated 18/12/2019 and the order of sentence are request and set aside. The accused who are in custody be set at liberty forthwith if not required in other case, or any accused appellant so and so are directed to furnish personal bond of some so and surety bond of this before the registrar with 2 weeks from the date of release of the effect. In the event filing the special relief petition against this judgment or grant of leave, accused of so and so on receipt of notice shall appear before the Honorable Apex Court. The bail bond will be effective for a period of 6 months. It is apparent that the investigation was not fair. See, this is very important. It is apparent that the investigation was not fair, and it appeared that nefarious means were employed by the investigating agencies. Material witnesses required to unfold the events were betrayed, and apparent manipulation and fabrication have been done during the investigation. We therefore deem it proper in the interest of society, justice, and morality to direct the Director General of Police Rajasthan to initiate appropriate inquiry, disciplinary proceedings against the erring officer of the investigating team. This is very important. This was a thing which I wanted to highlight. Since sealed articles are opened in the court, the registrar judicial is directed to receive the same and return to the record to the trial court forthwith. All the pending applications are disposed of. समीर जैन साहब क्या बोलते हैं? I have had the pleasure of reading the academic and erudite judgment uttered by my brother judge, and I am in complete and respectful agreement with him on every point involved. However, having regard to the importance of the issue involved, I deem it appropriate to pen down a few of my own views in addition to the opinion of my brother judge. The following observation and direction are common to all the death sentences and appeal adjudicated irrespective of the fact that said death sentences and appeals were adjudicated individually and independently on their own fact and argument in great details in the part of the judgment. At the outset, the well-established rule of criminal jurisprudence of favor the crime, higher the proof is required to be noted. In the instant that the life and liberty of the convict who are individual is taken at the accused. As the accused were given death sentence, a very careful, conscious, and meticulous approach was necessarily required to be made. It is well settled that the prosecution must stand or fall on its own leg, and that it cannot derive any instance from the weakness of the defense. It is also settled law that whenever there is two possibilities, one reasonably indicating commission of crime and the other reasonably indicating occurrence of innocence of accused, the accused must be given the benefit of doubt. When any fact asserted by the prosecution are doubtful, the benefit should go to the accused and not to the prosecution. That is the settled position law. In this regard, alliance is placed on is invited upon the judgment of Honorable Court in Digambar Vaishnav and so and so. क्या जजमेंट है? मस्त जजमेंट लिखा है. Bearing these principles in mind, the court have consciously decided both the references and appeal in favor of the convict. The court has observed that the learned trial court has earnestly relied upon individual evidences, ignored material contradiction, and has also not properly considered the legal provision enumerated in the Indian Evidence Act for this Information and Technology Act and the Code of Criminal this. In the instant matter, the following chances are noteworthy. The blast occurred on so and so in the city of Jaipur. Subsequently, after 4 months, similar blast took place in the capital city of on 13 September. For these 4 months, little to nothing was done by investigating agencies in the state of Rajasthan. The special cell of Delhi and a tip operated the Batla house and so and so. Only one of the accused, Muhammad Saif, was abandoned as his apprehension was recorded. Prosecution has attempted to disguise the alleged statement made by the accused. The alleged trouble made by the accused convict between Delhi and Jaipur has also not been conclusively proved. No CCTV footage and no call details were produced from the seized mobile from the accused in order to support the alleged this email listed by the accused assuming responsibility of the blast on the media, including so and so was either supported by the mandatory certificate as required under so and so. Now it was corroborated with the statement of the Prakash Ranjan or other people from the media houses who received such mail in the absence of mandatory certificate as required under so and so as held by the apex court in this and in absence of corroborative statement of exam, this and other people. In the case of prosecution, that the accused convict allegedly sent the email from Naveen Cafe operated by Mr. Madhukar Mishra. However, the relevant CPU and the relevant register record were never seized and examined. The site plan prepared is also not reflected in the existence of relevant CPU system. All this added with the fact that Mrs. Madhukar was not present on the spot at the relevant time cast a pseudo doubt. The investigation agency also failed to impound, seize at the initial stage of the investigation the relevant bill books from the bicycle owner. There was no scientific evidence examining or comparing the ball bearing size seized from the site of blast and that seized from the shop of Subhash Chandra. There were mismatch of the size of ball bearing which were produced. The test certification report is also vitiated for non-compliance of Rajasthan Police manual. The prosecution also failed to examine some of the key witnesses. The most crucial example of this is the absence of examination of Rajan Singh Nayan, who allegedly conducted the entire investigation with cycle shop vendor. Other important witnesses who were not examined include A.K. Jain, Prakash Tandon, and other people from the media who allegedly received the mail. Having regard to the totality of the discussion and the evidence of the record, it is difficult to hold that the prosecution had proved the guilt of the accused by reducing cogent and clinching evidence as per the settled legal position. In order to sustain conviction, the circumstances taken cumulatively should form a chain to complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused only and not no one. The circumstantial evidence must be complete and incapable explanation of any other purposes that on the guilt of the accused and such evidences. The court is content to make these observations as the court has noticed, as mentioned above, many glaring lapses having occurred during the course of investigation. It is noted by the court that the investigating agency has miserably failed in discharge of the duty they have performed poorly. The investigating has not only flawed but also shoddy, and the provision of law as well as their own rules were overlooked. It is also observed that by this court that the investigating agency lacked the required legal skill as they were not aware about the statutory prescribed and mandatory requirement. They have approached the case in a careless manner, that is unbecoming of member of uniformed post. The approach of the investigating agency was plagued by insufficient legal knowledge, lack of proper training, and insufficient expertise of investigating procedures, especially on issues like cybercrime and even basic issues like assembly of the failure of the part of the investigating agency has frustrated the case of prosecution, and the evidence so recorded is not fulfilling the chain of evidence. Though the effort of the arguing counsel Rekha Varnani so and so have to be appreciated, but it is also glaringly obvious that in the present case, no integrated approach was adopted by the state. It was also admitted in written submission that since the matter was first of its kind, certain technical errors were there on the part of the state to carry out the investigation, and therefore the seizure, non-production of evidence, non-production of material witnesses as have not taken under Section 7 of the list of Constitution of India. The police is a subject governed by the state whose primary role is to provide security to the people, to investigate the crime and to maintain law and order. It is indeed true that there have to be given a personal freedom to carry out their role and responsibility while discharging the important this. For the reason stated, we hold the investigation agency in the given case should be made accountable for the negligent, cursory, and efficient action. In the given case, for the reason stated, in spite of the case being heinous nature, 71% losing their lives and 185% sustained injuries, causing unrest in the lives of every citizen, not just in the city of Jaipur, but all across the country. We deem it appropriate to direct the Director General of Rajasthan Police to initiate appropriate disciplinary proceeding against the erring officer of the investigating team. Before parting, it must be added that the course in case of Prakash Singh and others in Union of India had contemplated formation of a police complaint authority, which is still not adequately constituted in the state of Rajasthan. This is a case of classic example of institutional failure, resulting in both fraud, shoddy investigation. We fear that this is not the first case to suffer due to failure of investigation agency, and if things are allowed to continue the way they are, this certainly won't be the last case in which administration of justice is affected due to shoddy investigation. Therefore, we direct the the chief secretary in particular, to look into the matter, which is in the larger interest. Now, ये जजमेंट मैंने आपको पढ़ के सुनाया। पूरा तो नहीं पढ़ा क्योंकि पूरा पढ़ते-पढ़ते तो करीब 2-3 घंटे लगते थे। लेकिन फिर भी आप इस जजमेंट को देख करके, इसको अगर कहीं पर साइट में मिलता है तो पढ़ कर के ये अंदाज़ा लगा सकते हैं कि पुलिस किस तरीके से उन ज़िंदगियों के साथ खेलती है, जो इस सीरियल ब्लास्ट में मारे गए और जो घायल हुए, और किस तरीके से इन्वेस्टिगेशन किया। जो जजमेंट खुद बोल रहा है कि सॉडी था, ये था, वो था। तो अब देखते हैं कि राजस्थान गवर्नमेंट क्या करती है। मुझे तो ऐसा लगता है कि राजस्थान गवर्नमेंट इस जजमेंट के खिलाफ सुप्रीम कोर्ट में जाएगी, एसएलपी फाइल करेगी और फिर कोई फैसला आएगा। बट टिल दैट टाइम जिन लोगों को मौत की सजा मिलनी थी, वो मिल गई। यहाँ ये बताना ज़रूरी है कि अगर बेनिफिट ऑफ डाउट है, तो वो हमेशा एक्यूज़ को दिया जाता है। ये क्रिमिनल का ज्यूरिस्प्रूडेंस है। ये एक इम्पोर्टेंट जजमेंट मेरे हाथ में आज लगा था, जिसको मैं आप लोगों के साथ में शेयर करना चाह रहा था और मैंने शेयर कर दिया। आशा है आपको ये वीडियो अच्छा लगा होगा। अगर अच्छा लगा है तो इस वीडियो को लाइक करें, दोस्तों सोशल मीडिया में शेयर करें, मेरे चैनल को सब्सक्राइब करें और कमेंट ज़रूर करें। मेरे नेक्स्ट वीडियो को पाने के लिए बेल आइकन को दबा दें, जिससे कि आने वाले वीडियो आपको मिलते रहें। धन्यवाद, नमस्कार, शुभ रात्रि, टेक केयर। जय हिंद, जय भारत।